Good afternoon, everyone. My name is Peter Neufeld. I'm a partner at the firm Wagner Sidlofsky LLP and the co-chair for this Lunch and Learn series on issues in family and estate law, along with my colleague, Professor David Friedman. The subtopic that we are speaking about today is setting aside domestic contracts post-mortem, that's after death. A paper was prepared for this seminar by Aaron Franks, David Wagner, and Lucinda Bendu in advance of the seminar for this topic, and a link to that paper can be found in the Zoom chat. Maddie will be adding that to the Zoom chat. There will also be a certificate of attendance posted in that chat for you to download. Both of those will be in the chat momentarily. A few housekeeping notes. Make sure that you have your microphones muted at all times, unless you're asking questions at the end of your presentation. You're welcome to ask those questions by just unmuting yourself and asking the presenters. You can write something in the chat if you're less bold. Either way is fine. Please also note that the seminar is being recorded. Also, if you ask a question, just remind yourself to mute yourself once you're done asking the question. We've got two presenters today, Aaron Franks and David Wagner. David Wagner is a partner at Wagner Sidlofsky LLP. He practices exclusively in commercial and estate litigation. David is routinely involved in dependent support applications, important for today's topic, in addition to many other aspects of estate and trust litigation, including will challenges, executor and accounting disputes, as well as acting as estate trustee during litigation. Aaron Franks is a partner at the firm Epstein Cole, which is one of the premier family law boutiques in Canada. Aaron's practice encompasses all areas of family law. He has acted as counsel at all levels of court in Ontario, including the Supreme Court of Canada. He is currently an adjunct professor at the University of Toronto Faculty of Law and a former adjunct professor at Osgoode Hall Law School, teaching family law. He has been on the editorial board of the Reports of Family Law since 2005, and he is the co-author of Franks and Zalov This Week in Family Law, which is a weekly family law newsletter published in Family Source by Westlaw Next Canada. So needless to say, we've got two very qualified presenters here today to talk about the issues of setting aside domestic contracts post-mortem. Thank you very much to our sponsors today. They're the reason that today's seminar is complimentary. In particular, I'd like to thank Scotia Wealth Management, the Brith, Epstein Cole, Concentra Trust, BMO Private Wealth, TD, Torkin Baines, Solus Trust, as well as WeirFoulds. If you've enjoyed today's seminar, or if you attended the seminar 2 weeks ago and you enjoyed that, we ask that you consider making a donation to the Brith Canada Food Program if you haven't already, or if you already have and you want to do it again, please do that. The link for to make that donation will be posted into our chat. I see Maddie's done that now. Richard Robertson, who's the Director of Research and Advocacy of Brith, is here with us today to tell us a bit about the organization and its charitable work. So Richard, assuming you're there, you have the floor. Go ahead.
Thank you so much, and thank you all for joining today's seminar. Our university campuses have become a flashpoint for anti-Semitism in recent weeks. Many people have been concerned about the development of unauthorized encampments on university campuses across Canada and the untenable state of affairs for Jewish students and their allies on campuses. So I wanted to share with you a little bit of the brief work that B'nai B'rith's Advocacy Department is undertaking to help protect students' rights on campuses. We're currently engaged in litigation in Quebec against the Student Society of McGill University. The reason that this litigation was required is that the Student Society at McGill University was passing motions at their annual general meeting that are against the memorandum of understanding with the university. We implored the university to take action on behalf of the students who were prejudiced by these motions. The university failed to act, so we are now engaged in litigation to prevent, and we've succeeded with interlocutory injunction, which prevents these motions from being ratified, but we're hoping to have the court dismiss these motions as being contrary to the memorandum of understanding. We also recently participated in the committee studies and made submissions on Bill 166 in Ontario, which was recently adopted by the provincial government last week. Bill 166 provides the Minister of Post-Secondary Education with the ability to implore via directives, ministerial directives, universities to comply with the bill's new requirements, that they develop strategies geared towards combating racism and hate on campuses. So B'nai Brith will continue their work with the provincial Minister of Post-Secondary Education to ensure that those directives are being utilized in a manner that allows for the protection of all students and holds universities accountable to developing strategies that can actually have an impact. This week, I will be in Ottawa for the Federal Justice Committee's study of anti-Semitism and Islamophobia on campuses. B'nai Brith will be making submissions about an action plan in relation to our audit of anti-Semitism. Earlier this month, we released our audit of anti-Semitic incidents. Unfortunately, we saw over 100% increase in anti-Semitic incidents across the country, close to 6,000 incidents. Particularly troubling was the over 200% increase that we saw in violent acts of anti-Semitism across Canada. So we're very grateful to have been selected to make submissions in this study, and we'll be using the information that we compiled for our audit to demonstrate that the time is now for our federal government to intervene to stymie the rise of anti-Semitism that is impacting our students. And I just want to add one thing. If you want to be involved in helping to combat anti-Semitism, or you're looking for an amazing way to connect with other like-minded lawyers, please feel free to join B'nai Brith's Maidus Law Society, and the information for the Maidus Law Society is available on our website. We provide CPD seminars, networking opportunities, and also volunteer opportunities for lawyers that are interested in helping us advance our advocacy work. Thank you very much.
Great. Thank you very much, Richard, for that. Appreciate it. We're going to start off the presentation now. I believe Aaron's going to begin. Go ahead, Aaron.
Thanks very much. And thanks very much for inviting me. So I'm going to talk a little bit about setting aside domestic contracts. But before we talk about setting aside domestic contracts, we have to talk a little bit about what is a domestic contract and what you can do to try to ensure that your domestic contract is not set aside. And then I will hand it over to David, who will talk about what happens when you're trying to set aside a domestic contract. One of the parties happens to be dead, which makes things a little bit more complicated. So domestic contracts get a bad rap. They have a bad reputation. A lot of people, some lawyers, some lay people think that domestic contracts tend to not be worth the paper they're written on, that they're set aside all the time. And that simply isn't true. It certainly seems like it's true sometimes because of the amount of press that cases get when contracts are overturned. And the reason for that is likely because when a significant marriage contract is overturned, perhaps by a contract that was done by a prominent Canadian family, well, that is something that is newsworthy, and because of the open court principle, we all hear about it, whether it be in the Star, the Globe and Mail, the Post, what have you. But when a contract is upheld, that's not terribly newsworthy. Marriage contract upheld will never be in the headlines because it's not terribly interesting. So there's this sort of general feeling out there that marriage contracts, cohabitation agreements really aren't worth anything, but that simply isn't the case. These are contracts that are provided for in the Family Law Act. They are commonly used, and more are upheld than not. It's just that people sometimes don't understand that to be the case. That said, there are absolutely domestic contracts that are set aside. And the key to having your domestic contract not set aside is to ensure that it's done properly. So we're going to talk a little bit about how a domestic contract is done properly, and then where some of those rules aren't followed, it can become easier to have a contract set aside. And as I say, then I'll hand it over to David. So the rules of domestic contracts, and when I speak of domestic contracts, I'm talking about marriage contracts, which are usually done by parties that are intending to get married or that are already married. or cohabitation agreements, which are agreements between people that are living together who may or may not intend to get married, and then separation agreements, agreements between people that either may have been married or may not have been married, but living in a common law relationship and have decided to separate. So those are predominantly the domestic contracts we're talking about. The Family Law Act provides for other contracts, but those are the ones we're going to focus on. So most particularly, we're going to talk about marriage contracts and cohabitation agreements, because then those they tend to be the most interesting. And so when parties come to me to talk about and say, listen, we want to do a marriage contract, we want to do a cohabitation agreement, the first question I usually ask is, well, when's the wedding? Very often the answer is, oh, next week, or a week from this coming Thursday. And my usual answer is, well, that's simply not enough time to get something like this done. Marriage contracts do take some time, except for the most very, very basic marriage contracts. We're talking about a lead time of an absolute minimum of 30 days or 60 days. And by the time I'm finished speaking, you'll understand exactly why. So that's the first thing. Although the Supreme Court of Canada, in a case called Hartshorn, did not set aside a contract, even though it was signed the day before the wedding, it's still best practice to not have a contract signed before the wedding because it simply leads to suggestions of duress and the like. So the first question is there enough time to actually get it done properly? And if there's not enough time to get it done properly, then we have to sort of do other sort of placeholding measures like standstill agreements to allow the parties to get married and then perhaps come back and negotiate a contract afterwards. So as I say, the Family Law Act provides for these entities called domestic contracts. And how do you make one that is enforceable? Well, first of all, it has to be most basic. It has to be in writing. It has to be signed by the parties. A contract that is oral, a domestic contract that isn't in writing, a contract that isn't signed by the parties is not a contract at all under the Act, and it's not enforceable. The Act provides that there are specific ways to ensure that a contract will be enforceable, and certain things that if are not done will lead to the contract being tossed. By far, the most common way to set aside a domestic contract, be it marriage contract, cohabitation agreement, or separation agreement, is lack of financial disclosure or misleading financial disclosure, or even accidents in financial disclosure. So there's a section of the Family Law called Section 56 that actually deals with exactly this. But I cannot overemphasize the importance of doing proper financial disclosure when it comes to doing marriage contracts and cohabitation agreements. And when I talk about proper financial disclosure, we're talking about it doesn't have to be a sworn financial statement, but it does have to be a listing of all the assets and liabilities that the party has in the world. And it's actually a very important exercise to do because the more complicated the situation, the more accidents are prone to happen. And the way we do things in our office, because it is the most common way to set aside these contracts, is we will work with our client. We will put together, sometimes it'll be in the form of a financial statement, sometimes it'll be in the form of an annotated net worth statement, but we will list all of the assets, we will list all of the liabilities, and then we'll have a disclosure brief that actually details all the entries on the financial statement or on the list of disclosure. And then we will do a cover letter and say, here's all the financial disclosure for our client, Mr. Smith. Here is the disclosure brief attached to it. If you have any questions at all in the world, just ask. That then gets sent off. And then in 20 years, if somebody ever were to suggest, well, financial disclosure wasn't done or financial disclosure wasn't proper, we have this beautiful disclosure brief with a cover letter on top that says, we sent you everything. We told you to ask any questions. If they told you that if you didn't understand anything, all you had to do was ask. And he didn't ask any questions. Therefore, the time to be asking questions was 20 years ago when you got the disclosure brief, and not now when you're separating. That is the way that we sort of push the disclosure obligation, or push the risk onto the other side when it comes to dealing with disclosure. But it's very important that clients understand that this isn't an estimate. It isn't sort of a ballpark. It isn't, well, maybe I may have this, maybe I might have that. It actually requires someone to actually go and do the work. They have to go and get bank account statements. They have to go and get investment account statements. They have to go and get RRSP and TFSA statements. Those are sort of the no-brainers that have to be done because they'll go in the disclosure brief. They also have to make further inquiries. Some people are actually beneficiaries of trusts out there, and they don't know it. They have no idea whether or not the older generation has actually put in place financial provisions such as the family trust. it's incumbent upon people to ask. And this is actually sometimes, it becomes interesting because very often the older generation will not want to disclose. They'll say, we set up a trust 15 years ago. We never wanted our kids to know about it, and we're not going to tell them now. This actually causes some problems because if a trust is in existence and it's not disclosed and it's a trust worth anything significant, that is a one-way ticket to set-asidesville. So sometimes there have to be family meetings and like just to ensure that the client we're working with actually knows the universe of their own financial disclosure, and sometimes not. Now, the question often arises, well, how detailed, how accurate does it have to be? Well, it's really a matter of degree. If you swear in your disclosure statement or financial statement, whatever it may be, that you are worth $1 million by way of net worth before you get married, and it turns out you're actually worth $3 million, well, that's a problem because you were off by a very significant margin, and chances are the other side's going to have a very good shot at setting aside your domestic contract. However, if you're worth, we'll pick a large number, $20 million, and it turns out you're actually worth $22 million, that's not as big a deal, right? The difference between 1 million and 3 million, certainly on a percentage basis, is far more significant than the difference between 20 million or 22 million. And once you get contracts that, are into the stratosphere, people worth, or people are worth, tens of millions of dollars, again, there's certainly more forgiveness. The idea is to give the other contracting party some idea as to the wherewithal of the person that they are getting married to. And if they can't understand it, then that's the basis to set things aside. So people will often say, well, why don't we just guess really, really high? I might only be worth $5 million, but what the hell? Let's just say we're worth 20, because then they have reason to think I'm worth 20. The courts have said, no, disclosure has to be relatively accurate. So you can't materially overstate, you can't materially understate. If you do, again, that's simply going to lead to problems. There doesn't have to be bang on accuracy to the dollar or dollars and cents, but it does have to be a reasoned valuation. And for some more complicated assets like fractional interests in joint ventures and the like, yeah, sometimes it's very difficult to provide a value. And in that case, at the very least, you want to set out what the value that you're using is, set out how the value was determined, and then again, it all gets sent off to the other side. And if the other side disagrees with that value or has any questions, they can then ask. But it is fundamentally important because it is, as I say, the number one way these things get set aside. So it's not just a quick discussion. It has to be a lengthy discussion, and the client, as I say, has to do some significant work. Sometimes people will say, well, we've agreed that we don't have to make financial disclosure to each other. The Act actually provides that parties cannot waive financial disclosure. Doesn't matter if parties agree they don't want financial disclosure. It doesn't matter if they say, well, we think we know what each of us is worth. That may be an argument at some point in court, 15 or 20 years down the road, but it certainly isn't an argument. That is not an argument that you want to pin your domestic contract on. It might be something that you can argue in the future, but it's not as good as doing it properly now. So it really does have to be something that's done, and it can't be waived. Even for the most basic financial, even for the most basic marriage contracts or cohabitation agreements or separation agreements. The requirement for disclosure also applies to separation agreements, of course. How else do you have to ensure that? That's the number one way. The other rules that I tell people are that both sides, with respect to their contract, have to have independent legal advice. Now, curiously, in Ontario, it's actually not a legal requirement. There's no requirement in the Family Law Act of Ontario, as there is, for example, in the Family Law Act of BC, that both parties have independent legal advice. That said, I would never be involved in a marriage contract where both parties didn't have independent legal advice, because it is, again, simply a recipe to have the contract set aside. It is far too easy for one party to say, I didn't understand what I was signing. I didn't understand the implications of what I was signing. I didn't understand how what I signed varied from which I would have been entitled to, or varied from what I would have been entitled to under the Family Law Act had I not signed. For those of you that like Latin, it's a perfect recipe for non est factum. I did not understand what I was signing. The document I signed isn't what I thought we had negotiated. So personally, I will never, ever do an agreement with both parties not represented. If one side doesn't have the financial resources to pay for independent counsel, I will have my client cut the other side a check for $5,000, say, give them $5,000, tell them to go hire whatever, retain whatever lawyer they want, and they'll get their legal advice from them. We don't want to know who they retain. We don't care who they retain. It's entirely up to them. If they want a list of 5 different names, we'll give them a list of 5 different names, but there simply has to be a lawyer in place. Third, the other way to have a contract set aside is pursuant to the ordinary law of contract. The Court of Appeal in Ontario has confirmed in a case called Doherty that a marriage contract or a cohabitation agreement is really just a contract, and therefore the regular law of contract applies. So if you have a contract that's unconscionable or a contract that is susceptible to claims of fraud or misrepresentation or anything like that, the general law of contract will also apply to marriage contracts, separation agreements, and cohabitation agreements as well. So you have to must watch out for those as well. So those are sort of the 2 big rules. Financial disclosure is a must, and independent legal advice is a must. Going back to financial disclosure for a second, even though the Act only speaks of parties having to disclose their assets and liabilities, courts have interpreted that to also require that parties disclose their income as well. So also as part of the disclosure brief, when we send over, we will send over 3 years of income tax returns, 3 years of notices of assessment, 3 years of corporate financial statements if there's a corporation involved, copies of trust indentures, copies of trust financial statements if they exist. This is one situation where it is better to over-include than under-include. But that sort of takes care of the first two major ways. The third thing is that the contract overall has to be reasonable, right? Many people will say, listen, we want to do a contract where there's absolutely no property division or separatist to property, as people sometimes say, and we both want to waive spouse support. Sometimes that's okay. If parties are on their perhaps second marriage or sometimes third marriage, yeah, it's possible that you can actually do a contract that is separatist to property that calls for no support, where the parties are in their 50s or perhaps early 60s, and they are sort of on the other side of the hill in terms of developing wealth. It may be okay, but if you're dealing with clients that are 24 and 25 years old, both of whom are starting out, a separatist to property no support contract may last for 5 years, and it may be good for 5 years. But as soon as you start having kids, as soon as one party starts staying home and looking after kids, as soon as one party gives up a career to look after kids, or as soon as enough time goes by and things change significantly enough, with every day that passes, your contract becomes weaker and weaker. And that's precisely the opposite of what you want. You would like a contract, if at all possible, to actually become stronger the longer the marriage lasts or the longer the cohabitation lasts. And sometimes people will specifically negotiate or draft their contracts so that they actually do become stronger over time, and that entitlements increase over time. That gets over the hurdle of a contract arguably not being fair or alleged to not be fair. So those are sort of the primary ways that people will attack agreements or try to have them overturned. There's a distinction between having a contract overturned for bad financial disclosure or for not being fair or what have you, and a court actually awarding something in the face of the contract. And that can happen with spousal support. When it comes to property, as long as disclosure is done properly, chances are the contract is going to be upheld. As long as the disclosure is done properly and there's no duress, no unconscionability, no other problems with the contract as a contract, chances are the property provisions will be upheld. However, there are clauses in both the Divorce Act and Family Law Act that treat support a little bit differently. So we'll focus on the Divorce Act for the time being. And the Divorce Act specifically says that in determining where one party claims spousal support from the other, one of the things the court has to take into account are any contracts signed between the parties. And if they signed a marriage contract, or they signed a separation agreement, or if they signed a cohabitation agreement, that is a contract between the parties. And for some time, there was some argument about whether or not a support release, where one party in a contract says, I will not claim, and I will not claim support from the other, and fully release the other from ever having to pay support, whether or not that was binding or not. In a case called Midland and Midland from the Supreme Court of Canada, that certainly everybody here who are lawyers has heard about, the Supreme Court of Canada decided, spouses should be allowed to sort of negotiate their own deal. And it is really very much a different strokes for different folks kind of thing. And people can have their own bespoke agreements. And there may be things that are important to spouse A that aren't important to another spouse in spouse A's position. That said, when it comes to support, the court has an overriding jurisdiction to determine whether or not it will award support in the face of a domestic contract. And they came up with, as the Supreme Court often does, a three-part test. And really what the test comes down to is this. First of all, when the agreement was negotiated, was it negotiated in what the Supreme Court calls unimpeachable circumstances? Did both parties understand what they were doing? Was there proper disclosure? Were both parties represented by lawyers? Was one party under any sort of undue pressure from the other? If none of those circumstances exist, then yes, chances are the contract was negotiated in unimpeachable circumstances. The next question the court will ask, where one party is claiming support in the face of an agreement, is, well, did the agreement that we're talking about actually meet the factors and objectives that are baked into the Divorce Act? If they did, then they ask the same question about the current time. So they first go back and say, at the time the agreement was signed, did this agreement meet the factors and objectives? And then fast forward to the present, does the agreement continue to meet the factors and objectives of the Divorce Act? So based on that test, you can see why when we talk about a contract having to be reasonable, you want a contract that is going to stand the test of time and that perhaps gets stronger over time. And that's precisely why, if you have a contract for very young people that waives support and waives property relief, you're going to have some trouble with that sort of third part of the Midland test as set out by the Supreme Court of Canada. Now, the test set out by the Supreme Court of Canada was supposed to be a very, very high test. It was supposed to only take into account things that were truly, truly unanticipated by the parties when they negotiated the agreement. In fact, in a famous paragraph of Midland, the Supreme Court says parties are expected to know that employment situations may change and health may change and childcare arrangements may change. Those sorts of things will be unpersuasive when somebody looks to claim support in the face of a contract. But as tends to happen, over the course of time, the Midland test has sort of become judicially watered down, such that the number of the sorts of contracts it applies to and the situations that it applies to have become sort of wider. So although normally when we talk about changing orders and the like, we talk about it by plain material change. And although when we deal with Midland, it's supposed to be something much higher than just a material change, my concern is that over time it has become somewhat watered down and it becomes very easy for courts to simply order support in the face of a support release. Originally, the Midland case only dealt with a support release where we'll say wife had released the right to claim support or had released her entitlement to claim support in exchange for whatever may have been granted to her in the agreement. The breadth of situations where Midland applies has been judicially expanded to now situations whereby there is a fixed and non-variable support arrangement where support is perhaps payable $5,000 a month for a period of 5 years. Courts will now quite readily apply Midland to that sort of situation. You will also actually see courts applying Midland to situations where there's actually open-ended support, not to pay $5,000 a month for 5 years, but pay $5,000 a month, period, which is really meant to be subject to a material change, although courts will still try to apply Midland, but I suggest that that's actually a misapplication of Midland that was never meant to apply to an open-ended support obligation. But the moral is that courts absolutely have a supervisory jurisdiction over support, and that is one of the reasons that courts found that on the front end, when you're negotiating a marriage contract or cohabitation agreement, one of the things parties do have to include, aside from assets and liabilities, are details about their income and proof of their income. And that sort of plays right into the Midland test. So that's where I will leave it for now. And I will let David sort of pick it up. But if there's a moral to what I've said, contracts matter. Contracts are enforceable. They just have to be done right. And to have them done right, financial disclosure, independent legal advice, and they have to be fair and withstand the test of time. And don't try to do too much in your contract. Right? Better a party be more generous in the contract now than they face perhaps having it set aside at some point in the future, is the overall lesson. And what I try desperately to have some clients understand that don't understand why they can't just do the kind of contract that they want. Over to you, Mr. Wagner.
Thank you very much, Aaron. And it's always important for litigators to understand what goes into drafting and the factors that need to be considered when preparing an agreement like this, because it's easy for litigators to come into into a case after when things have gone awry and to criticize what's been done to date. But in order for us to do that effectively, we need to know what actually goes into preparing agreements like this. Now, when you're seeking to set aside a separation agreement or a cohabitation agreement of any sort, post-mortem, there's one key difference in that one of the parties has passed away. And that gives rise to certain evidentiary implications. There are certain limitation periods that people should be aware of upon death that also come into play when you're considering how to best approach the case and what to do. So I want to just briefly touch on those deadlines or limitation periods that anyone should be aware of when you're looking at setting aside or dealing with a cohabitation agreement where one of the spouses have passed away. And the first one that I want to just raise is the general limitation period that applies to estates and to deceased persons, which is 2 years from the date of death. Now, that is a very general limitation period. There are exceptions to it. There are things that go beyond the 2-year limitation period. There are shorter limitation periods that we need to be aware of. But as a general rule of thumb, it's 2 years from the date of death. The limitation period on their own can be a topic, an entirely different topic for a different day. But one of the other limitation periods or deadlines that people ought to be aware of is in the Family Law Act. And that has to do with the election under the Family Law Act within 6 months of the date of death. Again, that's not for today's topic, but since we're talking about what changes upon a person's death, that's something that people ought to be aware of. There's also a limitation period or a deadline within 6 months of issuing the certificate of appointment for the deceased person's estate to bring a dependent support application under the SLRA or the Succession Law Reform Act. Now, I'm reading those again since we're talking about the change in circumstances upon someone's death, but they're not for today's topic. So one of the most significant ways, though, that setting aside a domestic agreement differs post-mortem is the applicability of Section 13 of the Evidence Act and general evidentiary rules that apply. So Section 13 of the Evidence Act provides as follows. It says, in an action by or against the heirs, next of kin, executors, administrators, or assigns of a deceased person, an opposite or interested party shall not obtain a verdict, judgment, or decision on his or her own evidence in respect of any matter occurring before the death of the deceased person, unless such evidence is corroborated by some other material evidence. So Aaron took us through and talked about what sort of things we would look at to set aside a domestic contract. But in order to establish those things, we need to meet the evidentiary thresholds that apply. And Section 13 of the Evidence Act imposes an additional requirement that needs to be met in order to establish the evidence necessary to rely on in order to set aside a domestic contract. And what it essentially is intended to do, it's intended to protect against the inherent vulnerabilities that exist where a deceased person's estate is involved in litigation. Namely, the estate is at a disadvantage in that the deceased person's evidence is no longer available to respond to allegations made against the deceased person or to provide evidence as to what that person would have said had happened. And to help address this disadvantage and the inherent unfairness, Section 13 prohibits obtaining a verdict, judgment, or decision based solely on the surviving litigant's own evidence, and it requires corroboration by some other material evidence. It can be cumbersome, but its effectiveness is also somewhat limited because what is considered to be corroboration by other material evidence is somewhat open to interpretation. What constitutes other material evidence? What level of corroboration is necessary? Sometimes corroboration could be sufficient if it's just a piece of documentation. So for example, if the issue is whether or not a party got independent legal advice, if there is a certificate of independent legal advice, you could assume that that would be effective corroboration. But what if there is testimony of someone who is somewhat independent? Does that count as corroboration by some other material evidence? So this Section 13 of the Evidence Act raises an additional consideration that must be taken into account when litigating post-mortem and when considering the merits of your case and your probabilities of success. Now, technically, the topic today is about setting aside domestic contracts. But really, when we're approached as litigators about setting aside domestic contracts, particularly post-mortem, what we're really being asked by the client is whether or not there is a way to relieve them of the restrictions and their obligations under the domestic contract. And sometimes we have to come up with out-of-the-box solutions for that. And one of the ways that we can circumvent a domestic contract or domestic agreement, as opposed to setting it aside, is by pursuing relief for dependent support under Part 5 of the Succession Law Reform Act. So when we're defining the client's goal from a practical perspective, as I said, the goal in my view is really to avoid limiting the entitlement as per whatever it says in the agreement. Section 58 of the Succession Law Reform Act provides that where a deceased, whether testate or intestate, so whether they died with a will or without a will, has not made adequate provision for the proper support of his or her dependents or any of them, the court, on application, may order that such provision as it considers adequate be made out of the estate of the deceased for the proper support of the dependents or any of them. So the key terms there are adequate provision for the proper support of dependents. And what that means in any particular case is going to be different. And one of the ways that the Succession Law Reform Act is unique is that when considering what constitutes proper support, the courts can consider maintaining the lifestyle of the deceased prior to death. So if we look to Section 62 of the Succession Law Reform Act, it's under the heading determination of the amount, and the SLRA lists, I think it's 19 factors that are to be considered by a judge in determining the amount and duration of support under the SLR, under Part 5 of the SLRA for a dependent support application. And for today's purposes, subsection 62M provides any agreement between the deceased and the dependent as being one factor to be considered. And as we see in the case law, which is set out and detailed in the paper that has been shared and uploaded online, what we see is that a domestic agreement and the waiver of rights or entitlements under a domestic agreement are not necessarily determinative in that regard. It doesn't, if you waive your rights to dependent support in a domestic agreement, that does not necessarily mean that you are precluded from claiming support under Part 5 of the SLRA. But it's one factor to be taken into account by the court in determining the appropriate amount and duration of support. So while it's important to understand and to take heed of the issues that Aaron raised during his presentation of what we have to do, and in order to make a domestic agreement effective, we also have to recognize that no matter how hard you work to make it effective, there is still the vulnerability or the openness to challenge it in different ways or circumvent the attempt to restrict the entitlements in certain ways, such as Part 5 of the Succession Law Reform Act. But when we do that post-mortem, there are also additional considerations that we have to take into account, particularly from an evidentiary standpoint. As Aaron said, we have confirmation bias when it comes to this type of thing, where everyone, lay people think that domestic contracts aren't worth the paper that they're written on. And litigators, when they read the case law, look at the cases and see that domestic contracts are set aside and run the risk of believing that it's easy to set aside a domestic contract. And that's not the case. In reality, the cases in which the domestic contracts are set aside or circumvented are the ones that gain popularity because they're more interesting, for lack of a better term. But for the most part, where there is a domestic contract in place, it's going to be difficult to set it aside. It's going to be even more difficult to set it aside post-mortem. And while there are avenues to circumvent it, again, it's going to be difficult to pursue those avenues. So I see that there have been a lot of questions posted in the chat, and I'm going to turn the mic over to Peter to pose some questions.
Great. Thank you, David. Thank you, Aaron, for that presentation. Awesome, really informative. We've got a few questions from the audience. I'll try to distill them into sort of two main questions I see. The first one is, both will be for Aaron in this case. The first one is about independent legal advice. What if a party refuses to consult a lawyer for independent legal advice when drafting a domestic contract? Should you get them to sign a waiver of ILA, or is there something else that family lawyers should be doing?
Yeah, I hate those situations. And why do I hate them? I hate them because, you know, parties have the right at law to enter into these contracts. And if one side is saying, sure, I'll enter the contract, but I'm not going to retain a lawyer, that really puts a family lawyer in a hard spot. On the one hand, you want to help your client. On the other hand, if every lawyer in Toronto said, you know, I'm not going to help you out if the other side has no independent legal advice, then the party is going to have a choice of either not getting married or not doing a contract. So yeah, that I will, and it really is a gut sort of thing. In some cases where I really have bad feelings, I will simply say, listen, I just don't want to be involved in this. But if it looks like the other side simply genuinely does not want to have, doesn't want to retain a lawyer or doesn't want to pay for a lawyer and has some capacity to understand what the contract is about, yes, I will occasionally include in the marriage contract a specific provision that says, we'll say in this case, husband has advised that it's extremely important that he obtain independent legal advice to understand his rights and obligations under the contract and how those rights and obligations may differ from what he may be entitled to at law if there is no contract. He's been advised to seek ILA on a number of occasions. He has refused, and he hereby agrees that the fact that he doesn't have independent legal advice will not be a basis upon which to set aside the contract in the future. Have I done that before? Yes. Does it give me a bad night's sleep that night? Yes, but sometimes I just feel there's no choice. So I'm trying to help a client do what they want to do.
I saw a recent question that was just posted, and it's relevant enough to the question you just answered, Aaron. So I'll pose it now.
Sure.
Is the situation different if one of the spouses or both spouses in this case say, oh, you know what, we know what each other has. We've exchanged disclosure on this before without the help of lawyers. We don't need a lawyer involved in this case. Does the situation change then?
Where both clients then don't have lawyers?
I mean, I guess it would be one that would say that they don't have a lawyer. In that case, they say, well, we've already exchanged financial information. We don't need independent legal advice for that. Is that a different situation, or would you say it's kind of the same recommendation that you've already given?
So let's go back to the example I was using where it's husband that is saying, I don't want to get a lawyer involved. So in that case, I'm representing the wife. I will still perhaps redouble my efforts in that case to make sure the wife's financial disclosure is clear, well set out, and easy to understand. Perhaps even in more layman's terms than normal, still send the disclosure brief over to the husband in this case, say, here's the wife's disclosure. If you have any questions at all, please ask. So I've got myself covered that way. I don't particularly care if my client wife is 100% sure she knows what the husband's assets and liabilities and income is. I'm not as fussed about the husband providing the disclosure, but if my client, the wife, says, yeah, I know what he has, I'm not worried about him completing a disclosure schedule, believe me, there will be an acknowledgement that I have my client sign that says, I acknowledge that Aaron told me to get a sworn financial statement or a detailed listing of all assets, liabilities, and income. I've told him I don't need it, as I am positive I understand his financial universe, just to cover Aaron's ass in the event something happens in the future and it turns out, oh, who knew husband had $1 million invested in a GIC that he had forgotten about. So that's, again, that's it. Would I do it? Yes. Does it make me have a good night's sleep? Not so much.
There's also a couple questions here about trusts.
Yeah.
When you're providing financial disclosure and someone is a beneficiary, your client's a beneficiary of a specific trust, maybe a family trust, do they have an obligation to actually produce a copy of that trust, or do they just need to say, I'm a beneficiary of this trust. I've got this certain interest in it.
So when it comes to marriage contracts and cohabitation agreements, family trusts are the bane of the family lawyer's existence. They really tend to make things complicated. And essentially what I do is this. Number one, yes, I ask them to produce the trust deed because, again, I want to err on the side of over disclosing. If there are confidentiality issues or confidentiality concerns, we'll deal with them. Sometimes we'll say, we'll include a blank tab at the disclosure brief and say available for inspection of the offices of Epstein Cole anytime you want. And occasionally that happens. There's some families that want their private affairs to be private and not spread around. So sometimes we'll do that. But at the very least, in the agreement or in the disclosure schedule, we'll say, wife is one of 10 current beneficiaries of the Smith Family Trust. The universe of possible future beneficiaries of the Smith Family Trust include A, B, C, D, E, or all issue, what have you. Wife has never received any distributions from the trust, or wife has received the following distributions from the trust in the past 5 years. And most importantly, the current market value of the capital of the trust is X dollars, which is the part that people sometimes, especially family accountants and people in charge of family offices, have a big problem with, because they'll say, why can't we just provide the financial statements? Well, if the trust has investments, those investments have usually been held for a long time, and they're recorded at cost. So the current market value of the trust usually bears no resemblance to the financial statements, which usually results in people having to go out and get valuations for sometimes assets that are difficult to value and go get real estate appraisers. Sometimes these in complicated situations, these valuation exercises can cost $50,000. But if you're trying to protect 50 million, $50,000 is probably a good return on your investment. So that's, yes, I would, as a very long answer to yes, I would include the trust indenture, a trust deed if I can. I would include the financial statements if I can. And I would include details about the universe of the trust. And then in the verbiage of the contract, I would say this is the trust that's been disclosed. It's wholly discretionary. Therefore, my client wife's interest could be anything from 0 to the full value of the trust. And what better can you do? Like nobody without a working crystal ball can say actually what somebody's going to receive from a discretionary trust over the next 20 years.
Now I'll add another layer of complication to it. What happens, and this is a question from one of the audience members, what happens if you learn after you've signed a domestic contract that lo and behold, you are a beneficiary of this family trust. You had no idea it existed. You find out after you're married. Do you have an obligation to disclose your interest in that trust?
So first, I'd like to know which audience member asked the question, because I'd like to track you down and poke you in the eye. That is an excellent law school exam question is what that is. And that is the reason that I will on the front end make it very clear to people that you need to go and you need to ask your parents if there are any family trusts in place. And if they don't want to provide any details, we just need a yes or no to start. So that is where I push. And you develop sort of a bit of a gut instinct as to when there's likely been some tax planning or an estate freeze done at some point in the past. And you can often tell from what the current value of assets are as to whether or not something's been done in the past. But if that situation were to turn up and it, 5 years after the marriage, we were to find out, yes, there was a family trust of which we didn't know. And assuming we're talking about a family trust of some value and it's not just de minimis. Yeah, I think I would probably, well, the choices are twofold. Either you do nothing and claim ignorance at some point in the future, which leaves your contract on very shaky ground. Or alternatively, you disclose it now, say, my client just found out about this. It was kept secret from her. Here's the details of it. It's our preference to keep the contract exactly as it is. And if there's no response, at least your contract is on better ground at that point, because if nothing is done, you could certainly argue that the contract was thereafter ratified by no one making any changes to it.
All right, thank you very much. I'll give you a break for a moment. David, we've got a question here about sort of in your experience, what are some common mistakes you see dependents or potential dependents make before actually retaining a lawyer? So someone comes to you saying, I want support from the estate. I'm knocked out of the will, or I want to set aside this domestic contract and seek support. What are some issues that you see dependents having before they decide to retain a lawyer, and how do you deal with that?
I would say the most common mistake that I see is an assumption that you have no entitlement and there's nothing you can do about your situation. So people will sit on their hands, say, I gave up all my rights under the domestic agreement that I signed, and they sit on their hands, do nothing for several months, and then a year down the road, they turn up at our office and say, oh, I spoke to my friend, I signed this domestic agreement that says that I gave up my rights, but I understand that there may be a way to set it aside, or that there may be a different avenue to pursue. And sitting on your hands for a year can be detrimental and prejudicial to pursuing different avenues. As I alluded to during our discussion earlier, there are certain deadlines and limitation periods that apply, such as 6 months for a dependent support application from the issuance of the certificate of appointment. You can still pursue dependent support after that time period, but you do need leave from a judge, and you're limited to the assets that are remaining in the estate. So sitting on your hands and waiting is probably the most common mistake that I see, and the assumption that there are no avenues and you have no way to pursue any entitlement other than what it says in the domestic agreement.
Thank you, David. I want to talk about Form 13.1 statements. Aaron, can you talk to us a little bit about what a Form 13.1 statement is, and is it something that you have to produce when you're exchanging financial disclosure?
So Form 13.1 is the general family law financial statement that is sworn when parties commence court proceedings on the family law side of the fence. A lot of people will do when they're doing their financial disclosure, will do it in the form of a Form 13.1 or a Form 13, which is just cuts out the income part and just does current values of assets. Doesn't have to be, as long as it is a detailed and accurate listing of a party's income, assets, and liabilities. Doesn't really matter what form it takes, and it doesn't have to be sworn, and nor do you have to do all the things you would normally do on the separation side of things. I don't worry about contingent cost of disposition. I don't worry about contingent taxes. I simply worry about current market values for assets, liabilities, and current income.
Yeah. Well, thank you. And David, on the estate side, is there any relevance to having a Form 13.1 filled out? Is that helpful for dependent support claims?
It's something that we use as a tool to assist with dependent support claims. One of the, or several of the factors involved in assessing a dependent support claim have to do with information that is obtained through a Form 13.1, but it's not something that's strictly required. But we do use it as a guide for helping ascertain income, expenses, assets, all those sorts of things.
Cool. We've got a question here about the Supreme Court decision in Anderson. This question will be for Aaron. The question is whether the Anderson decision has impacted domestic contracts getting upheld or being set aside in Ontario. Do you have any thoughts on that?
So Anderson was a case that started in Saskatchewan. So it deals with their Family Property Act, which has one important distinction from the Ontario Family Law Act. And that distinction is there's a section in the Saskatchewan Act, I think it's section 40 if memory serves, that says that in determining whether to uphold an agreement, the court can actually consider any contract that is not a domestic contract. And that's exactly what the court did in Anderson. They considered that one provision of the Saskatchewan Family Property Act. Ontario doesn't have a similar provision. In Ontario, something is either a domestic contract or it ain't. Anderson does contain some, general, flowery language from the Supreme Court of Canada about contracts should be upheld and parties have a right to negotiate their own destiny, etc. But when you drill down into exactly what Anderson is about, it's about a very specific provision of the Saskatchewan Act that actually doesn't apply in Ontario. So that part of it doesn't really matter. It's also worth pointing out that Anderson dealt with a separation agreement, not a marriage contract. and I think that would be even if Anderson were to have broader application in Ontario, I think given given that it was about a separation agreement, I think it would be more appropriately applied only to separation agreements. But the long and short of it is interesting decision, certainly a good read just for what they say about domestic contracts in general, but I don't think actually suggests that a domestic contract that is not properly done in Ontario could be upheld because it otherwise was a contract that wasn't a domestic contract.
Thanks. We've got a question here. I see Esther Mendelson has a question, but wasn't able to raise her hand. But go ahead, Esther.
Actually, Peter, it's been covered.
Okay, perfect.
Thank you.
Let's see here. Okay, there's a question. What if neither party has a lawyer and one party drafts the contract? I guess the question to that will be, is that susceptible to being set aside? I would think the answer is yes, but Aaron, if you've got any further thoughts on that.
Yeah, I mean, I guess it really ultimately sort of depends on what it says, how it's written. Does it make sense? What I will not do in my practice is I will not take an agreement that one side drafted, or somebody drafts, brings it to me and says, here's the agreement we want, will you give me independent legal advice on it? No. They're complicated enough and dangerous enough, and I always have Law Pro in the back of my mind ringing little bells. If you're entitled to a contract, if you want the contract, I'm absolutely going to help you do it, but it's going to have to be done my way. In point of fact, there are family lawyers in Ontario and in Toronto even that will say we will not do we will not do marriage contracts, we will not do cohabitation agreements because there's just too much liability, too much risk, not enough reward at the end of the day, and they're just not worth the price of admission. And we had a debate here amongst my partners, and everybody decided that if we're a family law firm, it's a service we have to offer, but that doesn't mean that we have to offer it in all ways. We will offer it, but in the way that we think it's most protective for our clients.
Thanks very much. Okay, I probably only have about a minute and a half here, so I just want to wrap up. Thank you everybody for attending. This is the end of today's seminar. Really appreciate it. Please remember that the link to the certificate of attendance for today can be found in the chat. So download that before you leave, because you're not going to be able to access it on Zoom after you end the Zoom meeting. We're looking forward to seeing you at our next seminar. It's entitled Enforcing Support Obligations in Separation Agreements and Court Orders Against the Estate. That's on June 4th, 2024. It's going to be chaired by lawyers at the firm Torkin Mains. Craig Vanderzee and Megan O'Connor will be the presenters for that presentation. If you haven't registered yet for it, feel free to do so. Maddie will add the link into the chat for that. And as a final reminder, the link to the B'nai Brith Canada Food Program can also be found in the chat in case you want to make a donation. Thank you all very much for attending. We really appreciate the turnout, and we look forward to seeing you back here on June 4th.